Dr. Massie from Pacific Northwest Fertility here with Liberty from Northwest Surrogacy Center. So excited to be here today to address the legal landscape of collaborative family building. Just as a quick introduction, my name's Jamie Massie. I'm the director of the third party and collaborative family building program at Pacific Northwest Fertility. We are a clinic that serves all aspects of reproductive health care and family building, from oral medicine IUI, reproductive health assessments, all the way through things like donor egg, donor sperm, and gestational surrogacy. Collaborative family building is a really big part of what we do. We are very passionate about it. We feel like it is such a beautiful way for people to build their families, and it's, an area of expertise that we really feel strongly and passionately about. So really looking forward to having this conversation today. I told Liberty before we started, I say every single time we do a legal landscape webinar, I learn something new. And so excited to hear what I'm going to learn today too. Go ahead and give an introduction and then we can dive in.
Yeah, thanks, Dr. Massie. My name is Liberty Smith. I'm the legal director with Northwest Surrogacy Center. We are a full-service agency. We help families guide through their surrogacy process, from the matching process all the way to birth. We also have associated egg donor agencies in Tendon, Asia West. So when I say full service, we're pretty full service, except for the medical piece. We certainly rely on our fertility clinic partners for anything medical related. So pleasure to be here. I'm sure there's going to be a lot of questions about the legal process. We're going to talk to you from egg donor contracts, surrogacy contracts, to the parentage process. So I think Dr. Massie is going to start with some basic information about kind of the differences between egg donor process as well.
Absolutely. So just want to sort of get everybody on the same page, because I know people joining us today are probably at all very different stages of the process. So I want to make sure that everybody understands the language. I also want to say that this is intended to be interactive. So as questions come up, please put them in the chat. We want to get questions answered. So unless it's something that's very unique and specific to your situation, let us know what it is. Everybody's thinking the same thing, has the same questions, so don't be shy. That's exactly why we're here. So wanted to just get started with sort of differences between different pathways. So there are two different types of donor egg partnerships. And we used to call them anonymous and known. But in the modern age of genetic testing and Google image and all of the things, we no longer call them that. So now you'll see these different pathways referred to as directed and non-directed. So directed is historically a known donor, generally somebody that you know who has said, I will give you my eggs to use to build your family. Non-directed are what we used to call anonymous pathways, where people have agreed to donate their eggs to an unknown individual. And the legal processes between both of those things are quite different, because one has a contract with you as an individual and the other does not. So I'm going to let Liberty talk about those details. Yeah. There's different ways you can do it, fresh and frozen, but I think from a legal standpoint, really the big, difference is between the directed and non-directed pathways. When we talk about surrogacy partnerships, there are also different ways that people come to identify and work with a surrogate. And those tend to be categorized as working with an agency partnership like Northwest Surrogacy Center, or what we call an independent match, which means somebody identifies somebody that they want to be their surrogate, and then they enter into an agreement together without the aid of an agency. One thing that I think is really a benefit to working with an agency is the legal piece of independent matches. If you have never done this before, there are a lot of potential pitfalls, right? There are a lot of legal holes. And so when you work with an agency, they have done this time and time again. They can put you in connection with excellent resources. They can help you find the pitfalls and holes and make sure that you're very protected legally as you're going through this process. So just so you hear the language, directed is known, non-directed, anonymous. Independent, found that person on your own. Agency match means you worked with an agency to help identify that individual. As Liberty mentioned, we do all of the medical piece of this journey. So we cycle your egg donor, we create your embryos, we prepare your surrogate for the process, we do the embryo transfer. That's the part that your clinic does. Your agency does all the rest. So they have a big, heavy lifting job. And hopefully today we can shed light on the legal part of that.
And I think with like the directed and the non-directed agreements, even within those, there can be different communication guidelines as well. So your egg donor contract is going to outline, will you have direct communication with your egg donor? Will you have access to the registry? So usually with egg donation, they might register for like a donor sibling database so that if there are any medical issues later on, you can have access to those medical records for your child born through the egg donation. Or you can have completely kind of an open process where you know her name, you have a direct communication with her. You can send her an email and say, hey, my child's going through sports screening at school. Has there been any updates in your medical history? So even within those different egg donation process, you can have different levels of communication, and your contract will outline all of those things. As Dr. Massie was saying, even agencies with the egg donation side will have differences in their contracts. So the way that Northwest Surrogacy Center and our associated egg donor programs, Asia West and Intend, operate is we start a draft contract for you and we refer you out to independent attorneys. So that way, wherever your egg donor lives, you will have guidance from an attorney who's licensed in that state and experienced in third-party reproduction in that state.
Can you clarify that a little bit more? You emphasize state. Can you explain why that is important?
Yeah, so different states have different laws. So the federal government has not said anything about specific surrogacy or egg donor guidelines. We rely on the different states to have either a process through their state law or through case law about what those processes look like. So an attorney who's licensed in that state is going to have specific knowledge of what that state requires. So for the egg donor contract, there may be differences from a California contract to an Oregon contract or to a Washington contract. So there is an important part of working with an attorney who's licensed in that state. Typically, it's where your donor resides. It might be where your IVF clinic is. There's going to be different requirements depending on the state.
And is that true for both non-directed and directed donor pathways?
So for directed pathways, typically my understanding is that the donor might have a contract with the IVF clinic. So the IVF clinic, obviously, if you're working with Pacific Northwest, you're going to have a different contract with the donor. It's not going to be directly with the intended parents. When it's with the intended parents, you're working with attorneys, there's negotiations going on. If an intended parent is selecting, for an example, a frozen cycle, the IVF clinic already has access to those gametes, then that contract would be with the fertility clinic and not directly with that donor.
Absolutely. So just to clarify, if it's an anonymous or non-directed pathway, those individuals usually have an agreement with the agency they're working with, or if they're contributing eggs to a bank with the egg bank. So they have essentially said before you ever lay eyes on their profile or their eggs that they are relinquishing their rights to those eggs and you can use them. Is that right?
Yes.
Okay.
And that's an important part of even a directed contract is she is releasing her rights to those eggs. The intended parents get to make decisions on what happens with those eggs, whether they're created to embryos or destroyed. So that is part of the contract is that she's relinquishing any rights to those eggs.
Perfect. I think we have our first question. Let's address this and then we can circle back. Do we need a lawyer before creating embryos if we are planning to use them with a surrogate?
I think that depends on if you're using donor eggs or not using donor eggs. If you're using your own genetics to create those embryos, you may not have to work with an attorney yet. Once you're matched with a surrogate, you'll go through a legal process. Then you'll have a direct agreement with the surrogate. You will have a parentage process where you will be working with an attorney. If you are using donor eggs, then it's likely that you would have already worked with an attorney for that contract.
Yeah, that makes sense. And this question comes up a lot, who do we talk to first? Do we talk to a lawyer first? Do we talk to a clinic first? Do we talk to a donor agency first? And the truth is people come at it from many different angles, just depending on what you hear and where you're pointed. And we will get you in line, right? We'll figure out what you need to do next and how you need to make those next steps. In general, we really recommend that people who are planning a surrogacy partnership or a directed egg donation partnership, that they set up a legal relationship very early in the process. I think even if you're not planning on having embryos created for a little while, it is so important to understand the framework of what you need to do legally behind that. And sometimes that changes the path that people choose to take in terms of, do they want to do a directed or an undirected? Do they want to do an independent match or an agency match? So I think it's really valuable to establish that, partnership early in the process.
And the kind of caveat to that as well is that ultimately, where your legal process will take place on the surrogacy side will depend on where your surrogate lives, likely. So you may start working with an attorney in Washington. You may not work with that attorney all the way to the birth of your baby. You may work with a different attorney once you are matched with a surrogate. If she lives in a different state, you might want to start working with an attorney again who's licensed in that state. But I always recommend people talk to an attorney early and often. Those are going to be the best people who can guide you on the best process for you.
Is there a specific group or type of attorney that we should be looking for when we're entering into these arrangements?
Yeah, it's ART, so it's the assisted reproductive technology kind of attorneys. Generally speaking, they're going to be in the best case. You don't necessarily want to work with a tax attorney on this. They may provide you some advice, but they're not going to provide you the best advice for surrogacy and egg.
Absolutely, absolutely. You're very specialized, right? Just like we are in medicine. And so you want somebody, like I said, who's done these contracts many, many times and knows exactly what we're looking for, right? In terms of each component of those agreements. Okay. Let's see. We got a couple. Oh, good. Thank you. So if you look in the chat box, there's a link. This is a list of sometimes you'll hear them referred to as our attorneys, sometimes Quad A, just depending on who's referring to it. If it's the same group, if you go to that website, you can find a link with all of the attorneys in different states who specialize in that. Okay. What about FDA requirements after creating embryos? What are the legal requirements, if any? So I actually think this is more a medical question than a legal one. So the FDA gets involved when people create embryos for surrogacy partnerships because they see it essentially as a tissue donation from the sperm and the egg source to the surrogate. So it's literally similar to the process, like if you were going to give somebody a kidney. Even though that's a little bit overkill, it falls into that same category. It sounds very overwhelming, but FDA screening is actually pretty simple. It's just a risk questionnaire, a risk assessment questionnaire, a focused physical exam that's designed to look for evidence of advanced sexually transmitted infection, and then an expanded infectious disease panel. So it includes things like HIV and hepatitis B, and then sort of more random stuff like West Nile virus and CMV. If you are intending to create embryos for a surrogate upfront, so you have no embryos created and you know that you're going to be partnering with a surrogate, that testing is completed on the egg and the sperm source before embryos are created. And the testing has to be done within certain time windows. So for sperm sources, it has to be done within 7 days. And for egg sources, it has to be done within 30 days. If you're working with a non-directed donor, so an anonymous donor, that testing is completed in the window of time. So that's taken care of. If you're working like with eggs from an egg bank or sperm from a sperm bank, that FDA testing was completed and verified again before that profile is ever presented to you. For fresh egg donation cycles, for directed donation cycles, the FDA testing has to be done as part of that process. And so something that your clinic will really talk to you about for directed donations of sperm or eggs, when does that need to be done? How does it need to be done? And make sure that gets completed in time. For individuals who created embryos and now have decided that they want to partner with a surrogate or need to partner with a surrogate, in most circumstances, the FDA allows what's called retroactive FDA screening. So that means that you can do the testing now and apply the results to the embryos that were created. But that can only happen in circumstances in which the original intent was to transfer the embryos to the partner. Hopefully that makes sense. There's a lot of nuance to it, but that's sort of the general approach.
And I have a question about that, Dr. Massie. I know that the FDA has certain disclosure requirements, and I know that clinics do as well. Could you maybe talk on that if you are working with a surrogate, for example?
Absolutely. So the FDA does not necessarily tell us you cannot use eggs or sperm or embryos from this individual if they are positive for something like HIV or have a history of syphilis. Instead, what they require is disclosure to the recipient. So disclosure to the surrogate. And so part of our process in approval and consenting of your surrogate is to review the results of the FDA assessment and to provide that information to the surrogate, answer whatever questions that individual has, and then they make the decision about whether they feel comfortable or not comfortable proceeding. As far as we are aware, there has never been an infectious disease transmission from an embryo to an individual. So even in cases where there is a partner who is HIV positive, those are circumstances in which that disclosure from me to the surrogate is, this exists, the risk to you is minimal to zero, and in most circumstances, surrogates understand that and feel comfortable proceeding.
And I think you kind of brought up an interesting point that is super relevant to both the medical side and the legal side, is informed consent.
Yes.
So making sure that you are walking through each of those risk factors with a surrogate, that if she is receiving any kind of genetics or anything that does have an FDA disclosure requirement, but also part of the general process for working with a surrogate is that she's had at least one child before she's been through a healthy pregnancy and delivery. And that goes to informed consent as well, because she's able to make that decision for herself. She knows what her body has gone through for a pregnancy. So she's able to consent to this process as well.
Absolutely. I love that you brought that up because that's something that comes up fairly frequently, which is I have a friend, a partner, essentially, right? Somebody who's willing to be my surrogate, but they've never been pregnant before. We would not approve that individual as a surrogate because we feel like you cannot give fully informed consent about carrying or delivering a pregnancy until you've done so. So thank you for bringing that up. Really, really good point.
Yeah.
And if you work with an agency, that's never going to be in question. Part of their review and approval process, right, is to say, have you had a pregnancy before and was it healthy? That definitely applies when you're in circumstances of independent match. You want that individual to at least have had one successful, uncomplicated live birth. Okay, let's see. We have a couple more questions. If you work with Northwest Surrogacy Center, do they provide the attorneys needed? Or is that an additional cost? Or do we need to find an attorney where we live or where the surrogate lives?
That's a great question. So with our program structure, we include legal fees. That does include for both intended parents and surrogates. We will start the draft contract for you. So we start kind of the legal process at the very beginning with you, but we also want you to feel comfortable working with an attorney who is your representation. Same thing with your surrogate. We want her to have independent representation. So we refer you out to your own independent attorneys who are licensed in the state where your surrogate lives. So from the start, you'll be able to review that contract with your attorney. Your surrogate will review that contract with her attorney as well. The legal fees will be included in our program structure.
While we're on that topic, can you just walk through sort of what the timeline is for each of these pieces, right? Do you get a contract as soon as you sign up with Northwest Surrogacy? Like how does the timeline work?
Great question. Yeah, so with the different legal processes, so I'll jump back to egg donation quickly. That process is more expedited, I would say. Your egg donation window is a lot smaller than it is for surrogacy. Obviously, a surrogacy pregnancy, it's going to be a longer process than the egg donation.
Yeah.
That contract process starts when you've selected a donor, essentially. You'll work with your attorneys again. Generally, it's still going to be a few weeks as you're negotiating the contract, and then she'll start the IVF medication. Go to your clinic for the egg retrieval as well. So a bit of a longer period that she'll be at the clinic. My understanding is that she'll be there for the duration of that medication cycle, and then have the egg retrieval. So much more expedited process. Generally, we see about 3 to 6 months as people are doing the egg donation and embryo creation process. The surrogacy contract part will start once you're matched with your surrogate. So you'll have a fee agreement with your agency. That'll start when you sign up, but that's just between you and the agency. The direct agreement with your surrogate will start after you've been officially matched, after her medical records have been approved with your clinic. So they'll do that initial review on paper, and then she'll go back in person for an in-person screening once you're actually matched with her as well. That contract process can be a little bit longer. It's a lot longer of a contract. Our standard contract's about 30 pages, runs through a lot of different details about what your process will look like. We want to make sure that you can refer back to that contract and see, every step of the way, what does your contract entail? So that process takes a few weeks to a few months as you're kind of going through negotiations. And then the final step, which we haven't touched on yet, is the parentage process. That can take a few weeks as you're drafting your paperwork, the court's reviewing it, final parentage judgment is issued. But the states that Northwest Surrogacy Center works in, you'll have that usually completed while your surrogate is pregnant. So everything's in place by the time baby is born.
Clarify that a little more. You said the
Yeah.
places that Northwest Surrogacy Center works with, it'll be in place. Does that mean that there are some states where maybe will not be in place?
Possibly not. Yeah. So Northwest Surrogacy Center, we're only working with surrogates who live in 15 different states. Those are kind of the states that we've narrowed down as the safest places for surrogacy, whether that be legally or medically. And we always talk to intended parents about why that is, why those states are the ones that we've chosen. Part of that may be the parentage process isn't as clear in some states. So the states that we work in, typically you do what's called a pre-birth order process, which you do while your surrogate is pregnant. And a final parentage judgment is issued saying that you are the legal parents. Everything is in place by the time your baby is born. You're on the first version of the birth certificate. We do work in Minnesota as well. It kind of varies county by county there. Most oftentimes you'll be doing a pre-birth order, but there are states that you don't do a pre-birth order and you wait until baby is born. You have a court hearing after your baby is born. So we typically like to do those things ahead of time, just so that everything is legally clear by the time your baby is born.
If my surrogate delivers in a state where it doesn't happen until afterward, does the baby still get to come home?
Yes, you are still the parents. They will keep the baby. And it's very clear, something that we always walk through people is that we don't want your surrogate to take home the baby. She doesn't want to take home the baby.
No.
She's doing this.
Yeah.
So yes, intended parents would go home with the baby.
There's lots of questions, but I have one more and then we'll go to the questions. Are there certain components of the surrogacy intended parent agreement that you find are more discussed, meaning that there's some pieces that are just rote, right? That everybody's like, yeah, this is just standard. Are there pieces that really require quite a lot of conversation between the intended parent and the surrogate, a lot of negotiation between the parties?
Sometimes, we do have both sides request different things. I think that is the importance of working with an attorney who can walk you through what those different provisions mean. It may be that you review the contract and you don't have questions and everything as written is okay. But we want you to make sure that you feel comfortable asking questions and asking for those negotiations. So it really is going to vary based on personal preferences as you're going through and having those questions.
Okay. And she had mentioned that you do a medical record review, that we do a medical record review before legal is finalized. So part of the initial match process is your clinic, like Pacific Northwest, gets all of that potential surrogate's medical records. Agencies like Northwest do a very good sort of high level review of their surrogates, meaning it's not very commonly that we find something in the medical record that we say, no, this is a disqualifying characteristic, we're not going to move forward. But our job really is to go through that medical history with a fine-tooth comb. What we're looking for more than anything is sort of overlapping issues that can change risk profile, right? If somebody's got a slightly higher BMI, that's fine. If they've had prediabetes in one pregnancy, that's fine. But if they have a slightly higher BMI and they had high blood pressure in their last pregnancy, and that, right, these sorts of things then might change risk profile. And so we want to be able to bring that to you as the potential intended parent and say, this is how that might adjust risk. Does that feel comfortable to you or not feel comfortable for you? So that part of the evaluation will be completed before you finalize your legal agreements with that particular surrogate match. Okay, whole slew of questions. Here we go. So if we are using Northwest Surrogacy and we have a potential match, when will we be introduced to an attorney?
Yeah, so there is kind of a two different stages to that. So you're in your potential match, likely it's your clinic who's reviewing medical records at that point. You would be kind of pre-match meeting. So you may not have had that direct introduction to your surrogate yet. Once you are introduced to your surrogate, you have a chance to talk to her and ask all the important questions in working with her. What does that situation look like? If you say yes and she says yes to you, that's when you'll kind of start the contract process. So once you're officially matched with your surrogate, then we would introduce you to an attorney who's licensed in the state where she lives.
And at what stage of pregnancy does parentage begin?
We typically recommend beginning no later than 20 weeks. Most often we're actually seeing people start at around 16 weeks of pregnancy. We really want it to be in place by around 24 to 26 weeks, just so that if baby does come early, all of that legal paperwork's in order already.
Fantastic. All right. How might the recent executive order affect international intended parents using donor eggs and gestational surrogacy, particularly regarding parentage and the children's U.S. citizenship? This is a big one right now.
It is. And it's one that the parentage process we feel very comfortable is going to stay the same. That is dictated by the states that the surrogate lives in, not by the federal government. The question about US citizenship, there was just a Supreme Court case that came out in June that talked about a baby who was born in the United States is a US citizen. So we feel hopeful that those things won't change. I think the bigger question will be about the visas and parents' ability to travel. Again, we're hopeful. We probably think those things will stay the same, but we can't guarantee it. We're still kind of in a gray period of time where we're waiting to see what the government issues in terms of policies. So for right now, we're just kind of advising people, talk to an attorney, talk to an immigration attorney, see if your process would be impacted. We won't know more until we either see policies or we see a court order.
You mentioned immigration attorney. I think that's an important thing just to really highlight, that if you are an international intended parent, that part of your legal team should be immigration. All right. And so you have lots of legal advice and counselors sort of on both sides, both from your home country and from the United States, who can really help you navigate that part of the process.
Yes, absolutely.
Okay. And the sooner that you can get that information, the better. So, meeting with an immigration attorney if you're considering international surrogacy or international family building, I think is really, really important, right? You can do that before you ever even meet with a clinic, just to get an idea of if it feels like it might or might not be the right fit for you. And so that's a really important piece of the process that you can do at the very start. Okay. Let's see. Does the GC and IP intended parent have separate lawyers? And how do we ensure fairness of contract details for both parties?
Yeah, and I think that is the piece that ensures fairness, is that both of you will have separate representation. So intended parents will work with an attorney, that is their attorney. Surrogate and her partner, if she has a partner, will work with a different attorney. We want to make sure, again, like I was saying, that you feel comfortable making negotiations, that you're not represented by the same person. There can be an appearance of bias in that case. We want to make sure that this process is as fair as possible, and that really starts with having a separate representation.
Absolutely. And I always counsel people when they're picking their egg donor, this isn't a circumstance in which you want to be like, nah, they're all right, right? You really want to be super passionate about who you match with as your egg donor. And the same thing is true with your contracts with your surrogate, right? You should never enter into a contractual agreement with somebody until you feel 100% comfortable with what is included and not included in that agreement, and that you understand all of it. I think Liberty would agree that our job as counselors is to give you information and to make sure that you are comfortable. And there is no amount of question asking that is wrong. Right? We want these things to feel really crystal clear for both parties before you move forward. All right, let's see. I think there's some over here too. Can you speak to green card status as well, or is it the same advice?
Green card status for the intended parents, I'm assuming.
My assumption. Yeah, green card. If you are a green card holder, probably a green card holder living in the US who is an intended parent, what does that look like? Or do you have any insight into what that
Yeah, it's a little bit unclear. The executive order that recently came out does not specifically address lawful permanent residents. We, again, are hopeful that process won't change, specifically because you are living in the United States. You already have some legal status to be here. So we're hopeful that it won't change. But the executive order didn't specifically say anything about lawful permanent status.
Yeah. To flip that a little bit, do you have any insight into potential surrogate candidates who are green card holders in the US? Can they act as a lawful surrogate in the United States?
Northwest Surrogacy Center is not currently working with surrogates, just because we, again, don't feel like there is enough safety nets around the status at this point in time. We're hopeful, obviously, that may change, but as of this time, we're not working with green card holders. I think there are agencies who are comfortable taking that risk, but as generally kind of based on our history, we're started by attorneys. We're fairly risk adverse, and we want to, again, make this process, which is a human process. We can't control the risk in every sense, but where we can, we want to make sure that, we're putting safeguards in place.
Absolutely. We want people to work with agencies that protect them medically and legally and financially. And so absolutely appreciate a more conservative approach for sure. Okay, let's see. If you are here working with an employer under a work visa, I think that falls into sort of the same category, is that there's unfortunately a little bit of gray zone here.
A little gray zone. Again, we feel somewhat comfortable since you are here, you have legal status, you're not crossing a border in order to come pick up your child. But we don't know if the policies that will be instituted under the new executive orders, if that will specifically talk about work visas. We're hoping to have more guidance in the next 2 weeks. And I don't mean to say this in like this, the sky is falling kind of scenario. It's just that we don't know yet. And we hope to have more guidance, but our kind of job is to keep people informed. So we tend to err on the side of providing as much information as early as possible, as even we're still finding information out, because again, we want to make sure that you're making an informed decision for yourself as well.
Absolutely. And from a medical standpoint, I just want to say that once you have embryos created, the chance that your embryos are going to be successful in turning into live births doesn't change significantly over time. So the embryo creation part of this process is sort of time restricted, but the surrogacy partnership part is not as time restricted. So I would encourage people to move forward with their plans for embryo creation, because that part is impacted, right, by the age of the egg source, the age of the sperm source. But know that if you need a little wiggle room in order for some of this stuff to sort itself out, you're not compromising your chance of success. It's an extreme frustration because of time, right? And by the time we get to this point, everybody is ready to have a baby a year and a half ago. And so all of these pieces of delay just feel so overwhelming. But I think that it's important to know that from a medical standpoint and an outcome standpoint, you're not compromising anything by pausing until we have clearer information. Okay, let's see. I think we answered that one. Oh, this is an important one. Can you discuss termination rights by a GC? The recent case has us a bit worried.
Yeah. And that's understandable. I think going back to, is termination common in these cases? No. We've generally speaking had over 2,700 babies born into our program. We've only had 16 terminations in that time. So it's rare, just because, these are heavily tested embryos. The surrogate is screened and medically approved to move forward. But it is a great question to talk about. What if something did happen? And we do talk about it a lot, even though it's rare, just because it's such a hard decision for a family to have to go through and for a surrogate to have to go through that process. So during our screening, we talk about it often, and we align people based on their preferences. We don't want to ever put you in a situation where you're matched with a surrogate who wouldn't go through that process based on your wishes. So we talk about it often. Your contract will outline kind of your preferences on that point. So if you know that you would not terminate in the event of something like Down syndrome, your contract will include provisions on that. Understanding that it is for body, it is for choice whether or not to go through with that process. But we do talk about it often so that there's never a situation where you'd be in where your surrogate would refuse that process if that were requested of her.
I think the recent case, I think, really highlights every intended parent's deepest fear, right? That you're going to be in a situation where you want one thing and your surrogate wants another thing. And like Liberty said, this is a human process. And so no matter what safeguards everybody puts in place, there are going to be circumstances that are tragic like this that happen. I think we can say, as people who do this every single day, that this is a very unique and incredibly uncommon circumstance. We have had many, many patients go through this process, and in general, surrogates and intended families are very aligned, that they want the same things, that their goals are the same. And so I wish that we could say there's no chance that this would ever happen to you or your family. We can't, unfortunately, say that. But we can provide some reassurance that if you follow these processes, right, if you take the time, if you ask questions, if you communicate openly and honestly with your surrogate and with your agency, that we can really minimize the risk that a case like this would occur. Yeah. It is a hard one though. This
It is.
has
Yeah.
been a hard thing to watch, and our hearts go out to the people involved and to every single intended parent and surrogate pairs that are out there right now, trying to navigate this piece emotionally. It's really challenged.
Yeah.
Okay. Let's see what else. I think we talked about that they both have separate lawyers. Oh, so if we live internationally, are we able to currently have an embryo transfer legally within the Pacific Northwest or PNWF? Yes, you are. Yep. Yeah. I can't expand on that anymore because you are. Yeah, you can. Okay. Let's see if there's any other questions. We're sneaking up on time here. Less than 1% of the time. Oh, thank you, Molly. Molly put in a little statistic here just to put numbers on what we were talking about in terms of rarity, that less than 1% of the time, or 0.5% of the time, based on the current cases at Northwest Surrogacy, is how many times that the question about termination of pregnancy has even come up.
And I would say in each of those situations, the surrogate has agreed to go through with that process.
Yeah, absolutely. I think, you guys do a really beautiful job of aligning people. And, another sort of support of the agency process as opposed to the independent match process, I think, is that surrogates who go through an agency, the process to get to the stage at which you are available to match is very rigorous. You have to be very committed. It takes a long time. You talk to many, many people about the same thing over and over and over again. And so the picture that they get of that individual, what their beliefs are, what their ethics are, I think you have a very good picture of that as you go to match individuals, where that may not be true if you're doing an independent pathway. Just my own 2 cents. Let's see. Just to clarify, is it typical for an agency to incorporate the legal fees into their fees? As an intended parent, our attorney isn't a separate cost to that attorney. I think the question is, why do we pay, or do we pay the agency a legal fee and then pay our lawyer a legal
Great question. Yeah. So your legal fees would be included in our cost structure. So basically, you would retain your attorney. If it is the one that we refer you to, if it's a different one, that is okay if you choose your own attorney. We would pay their legal fees from the program fee that you've paid us, essentially. So you won't double pay them. The only scenario where it would be is that with our program structure, we have kind of an amount that we've set aside for legal fees. If the attorney that you've selected kind of goes beyond the standard rate that we normally see, which any of the attorneys that we refer you to would fall into that standard rate. If they go beyond that, you would just pay the difference in that cost. So we do include both your attorney fees and your surrogate's attorney fees in our cost structure.
All right. While we wait for these last couple of questions to come in, or if there's any remaining questions, I think we have contact information that we're going to put up for both Northwest and for Pacific Northwest Fertility. Please feel free to reach out. We would love to talk to you about your plans and your process. You don't have to be committed to any specific thing. You can be so early in just deciding if this is the right path for family building for you. But we really, like I said, feel very passionate about getting people information so that you can make choices that feel timely and appropriate for you. And they should be in the chat box here. I also think that we're recording this, so if there's anything that you missed or that you want to hear again, you should be able to get access to it online as well.
And as Dr. Massie was saying, if we did miss something, if you feel like there are questions that you still have specifically about your own circumstances, please don't hesitate to schedule a consultation with either Pacific Northwest if they're medical questions,
Absolutely.
Or Northwest Surrogacy Center if they are specific questions on surrogacy or even egg donor as well. We look forward to talking with families. This is part of our daily process, and this is why we do it. We love talking to families and getting to hear their situations and helping answer their questions.
Absolutely. All right. Well, thank you so much for joining us today. Always a pleasure. And we'll see you back at another one again soon, I hope.
All right.
All right.
Thanks, everyone.
Good day, everybody. Bye.